All right, welcome back to the Deep Dive. Today we're going deep on something that you're going to run into no matter what, whether you're signing a lease for an apartment or maybe getting into some kind of business agreement or even just, getting some work done on your house.
Mm-hmm.
And that's liquidated damages.
Right.
Liquidated damages.
It's right.
Liquidated damages.
It's a big one.
It is.
We see it all the time.
Especially here in California.
Especially here in California.
So we've got a bunch of, we've got legal guides and FAQs. We've got all kinds of stuff.
Absolutely.
To try to figure out what they are, how they work, and most importantly, when they actually are enforceable.
Right. And we're going to give you a clear understanding of liquidated damages so you know what you're dealing with when you encounter them.
Okay, so let's just start with the basics. What are liquidated damages?
Liquidated damages.
Yeah, what are they? How do they work?
Okay, so imagine this. You and another party are entering into a contract, and you agree that if one of you breaches it, you cause a loss, right?
Right.
And that loss is really difficult to calculate precisely. Think about the ripple effect of a delayed project, for instance.
Uh-huh.
Then the breaching party will pay a specific predetermined amount.
Yeah.
And that's essentially what liquidated damages are. A pre-agreed upon compensation for potential harm.
So it's not just like some number that somebody throws in the contract.
Absolutely not. No, there's much more to it than that.
There's more to it. Okay.
The core idea is that this amount, it's intended to compensate the party who suffers the loss, not to punish the one who broke the agreement.
Oh, okay. Okay.
So including these clauses, it aims to create predictability. It aims to help you avoid those really long and expensive legal battles, right?
Yeah.
Trying to quantify exactly how much damage occurred. And naturally, it encourages everyone to stick to their end of the deal.
Right. Okay.
Yeah.
So if I'm on the receiving end of a breach and there's an enforceable liquidated damages clause, like I don't have to go to court and try to prove how much money I'm owed.
That is exactly right.
Okay.
If the clause is legally sound, that predetermined sum is likely what the breaching party will owe you.
Got it.
Yeah.
Okay. So when are these clauses actually enforceable? Like what makes them stick, legally speaking?
That's a great question. Generally, for a liquidated damages clause to hold up in court, the amount that was agreed upon needs to have been a reasonable estimate of the potential losses
Okay.
that both parties anticipated when they first entered into the contract. And that timing is really critical.
Okay.
Courts will look back
Okay.
at the circumstances when the contract was signed, not just when the breach happened. It's
Okay.
really important to remember that.
So it's like at the time we sign this, we have to think about if things go wrong,
Exactly.
what might the damages be?
Right. And enforceability is much more likely when the actual damages that could result from a breach would be genuinely difficult or even impossible to quantify accurately at the time the contract is being created.
Right.
The clause serves as a practical solution for those situations where precise calculation is a real challenge. Think about a specialized service agreement where failure to perform could lead to lost opportunities, for instance.
Yeah.
Those can be difficult to put a specific dollar figure on,
Uh-huh.
right?
Yeah. Okay.
And the purpose of this pre-agreed amount isn't to penalize the other party for messing up.
Okay.
It's really about fairness. The clause should aim to fairly compensate you, the non-breaching party, for your potential losses.
Yeah.
It should not be designed to act as a punishment.
Right.
And if a court examines a liquidated damages clause and finds that the amount is grossly disproportionate to the actual harm caused by the breach, they're very likely to strike it down, viewing it as an unenforceable penalty rather than legitimate compensation.
So it can't be like, okay, if you're 1 day late, it's going to be $1 million.
Right.
Like it has to actually
it has to be
be
reasonable.
connected to
Exactly.
what the actual harm was.
Absolutely.
Okay, now let's talk about California specifically. A lot of our listeners are here in California.
Right.
What does California law say about this, specifically Civil Code Section 1671?
Yeah, so in California, the general rule for most commercial contracts is that a liquidated damages clause is presumed to be valid.
Okay.
This is really important
Uh-huh.
for those of you in business because it means that if someone's arguing that the clause isn't enforceable, the legal burden falls on them.
Okay.
The party who breached the contract has to prove that the clause was unreasonable under the circumstances that existed when the contract was initially formed. This presumption can be a significant factor if a dispute arises.
So if I'm a business in California and I put a liquidated damages clause in my contract, the court's going to say, Yeah, this is probably fine.
Generally, yes. In most commercial contexts, the starting assumption is that these clauses are good unless someone can prove otherwise.
Got it.
And California courts, they use a specific two-part test to really determine whether a clause is enforceable. The first part asks, was the agreed-upon amount a reasonable forecast of the anticipated actual damages at the time the contract was made? What did the parties genuinely believe they might lose if a breach occurred?
Okay, so did everybody kind of think about what could happen at the beginning and
Exactly.
make a number that seemed fair?
Yeah, and the second part of the California test looks at whether the parties made a reasonable effort to estimate those potential damages, and crucially, whether it was extremely difficult or impractical to do so when they were initially creating the contract.
Okay.
Both of these conditions generally need to be met for the clause to be upheld under California law.
Got it. So they have to have thought about it, and they have to have tried to make a real number, and it has to have been difficult to come up with that number.
Exactly.
Okay.
You got it.
Now, what factors do California courts take into account when they're making those assessments? Like, what are they actually looking at?
Well, they consider a few things. They look at the estimated amount of damages itself. Does it seem to be within a reasonable range of potential losses? They'll also look at the overall circumstances that existed when the contract was first signed. Was there a level playing field in terms of bargaining power between the parties? Were both sides represented by legal counsel? And was the liquidated damages provision part of a standard pre-printed form contract? Form contracts often receive closer scrutiny from the courts.
Okay, so if it's just kind of like a boilerplate,
Right.
fill in the blanks thing, they're going
to look at it more closely.
Okay, so they're going to scrutinize those. All right, are there any situations in California where this kind of general presumption of validity doesn't apply?
Yes, absolutely. The presumption of validity we just discussed doesn't hold if there's another specific California statute that already provides a rule for such situations. More importantly, California has a different, much stricter legal standard for certain types of contracts that are particularly relevant to you as individuals. This includes contracts where you're buying or renting personal, family, or household items or services for your own use.
Okay.
And also, very importantly, for many of you listening, residential property rental agreements, when you're renting a place to live.
Right.
This is important for tenants.
Yeah, okay, so we're talking about consumer agreements and residential leases. The rules kind of change. How do they change?
They do. In those specific types of contracts, liquidated damages clauses are actually presumed to be invalid. So the legal burden of proof completely flips. Now it's the party trying to enforce the clause, typically the seller, or in your case as renters, the landlord, who has to prove that the clause represents a reasonable estimate of the actual damages, and that it was extremely difficult to determine those actual damages at the time the contract was made. This is a much higher legal hurdle to overcome. And this is a key area where, as tenants, your rights are strongly protected under California law.
So it's really different if I'm renting an apartment.
It is.
Versus if I'm, a big business signing a big contract.
Yes.
Okay. So a landlord, they can't just put any late fee they want in my contract.
Exactly. And specifically regarding residential leases, California law has historically been quite wary of liquidated damages that penalize a tenant for simply failing to pay rent on time.
Okay.
For instance, if a landlord tries to charge a late fee, they generally have to demonstrate that they made a reasonable effort before the lease was signed to calculate the actual harm they might suffer due to a late payment.
Okay.
This harm is usually limited to things like lost interest on the delayed rent and the reasonable administrative costs they incur in dealing with the late payment. The late fee itself has to be a reasonable approximation of those actual losses.
Okay. So they can't just make some crazy.
It has to be justified.
Okay. All right. So we've talked about this a little bit, but let's get down to brass tacks.
Okay.
What is the difference between liquidated damages that are actually enforceable and a penalty, which is not?
The core difference really comes down to the intent and the purpose of the clause.
Okay.
Legitimate liquidated damages are all about compensation.
Okay.
They're meant to make the injured party whole after a breach has occurred.
Okay.
To cover their losses in situations where those losses were genuinely hard to predict with accuracy when the contract was formed. A penalty, on the other hand, is an excessive or disproportionate amount that's really designed to punish the breaching party for not fulfilling their obligations.
Okay.
It goes far beyond simply covering the actual financial losses.
So the law in California and just generally doesn't like it when contracts try to punish somebody.
That is correct. California Civil Code Section 1671 explicitly prohibits punitive damages for a breach of contract.
Okay.
So if a court concludes that a clause labeled as liquidated damages is actually functioning as a disguised penalty, if the amount is just unreasonably high and clearly intended to punish rather than compensate, they will likely declare that clause to be invalid and unenforceable.
Got it.
Courts are always evaluating whether the amount is a reasonable pre-estimate of potential harm and not something that is unconscionable,
Okay.
meaning it's so unfairly one-sided and oppressive that it shocks the conscience of the court.
Got it. So can you give me some examples, like where do we see this in the real world?
Sure. You might see delay damages in construction contracts where a specific sum is charged for each day a project goes beyond the agreed-upon completion date.
Oh, yeah. Yeah.
Non-performance damages could be used if someone fails to deliver goods or services as promised. Early termination fees in some service agreements are another example, aiming to cover the financial impact of ending the contract prematurely. Yeah.
And then, we talk a lot about landlords and tenants on this show. What about in that context? Like, what kind of examples do we see there?
In residential leases, you might see clauses attempting to impose a fixed fee if you break your lease early.
Okay.
However, as we discussed, in California, these are presumed invalid.
Right.
A landlord would have to demonstrate that this fixed fee is a reasonable estimate of their actual losses resulting from your early departure, such as the cost of finding a new tenant.
Okay.
Simply stating a large fixed amount as a penalty for leaving early is unlikely to be enforceable.
Right.
Late fees for rent are another common area. And again, California law requires these to be a reasonable estimate of the landlord's actual costs due to the late payment.
Okay. So if you're a tenant in California,
Yeah.
and you see a lease and it's got some huge fee, if you break the lease, you should be like, whoa, hold on a second. This is actually legal.
You absolutely should. Understanding this distinction is crucial for protecting your rights as a tenant.
Okay, great. Now, just a quick clarifying question. If a contract is breached, who is actually on the hook for these liquidated damages? Who pays?
That's easy. It's always the party who breaches the agreement. They are the ones who would be obligated to pay the predetermined sum to the non-breaching party. For example, if you, as a tenant, break your lease without a legally valid reason, you would be the one potentially responsible for paying any enforceable liquidated damages to your landlord. Conversely, if the landlord breaches the lease, they could be the ones owing you liquidated damages if such a clause existed and was applicable to their breach. However, it's more common to see these clauses focused on potential breaches by the tenant.
Okay. So generally, it's the person who messes up.
Exactly.
Okay, cool. So let's bring it all home. What's the most important thing that you want our listeners to remember about liquidated damages, especially if they're a tenant here in California?
The critical takeaway for you as listeners, and particularly for renters in California, is that while liquidated damages clauses can appear in contracts, their enforceability, especially in residential leases, is not automatic.
Okay.
California law provides strong protections for tenants, and these clauses are presumed invalid.
Okay.
Landlords have a significant burden to prove that they represent a reasonable estimate of their actual losses.
Right.
And that those losses were genuinely difficult to determine when the lease was signed.
Got it.
Be particularly aware of fees for late rent or early lease termination, and know that your landlord needs to be able to justify these based on their real potential harm, not just as a way to punish you.
Got it. Okay, so if you are a tenant in California and you're looking at a lease, look really carefully at those liquidated damages clauses.
Absolutely.
They might not be enforceable.
Especially here in California.
Yeah.
Yeah.
And if you're in Orange County, Riverside, San Diego, or Los Angeles,
Yep.
and you're dealing with eviction, unlawful detainer actions, or just have questions about your rights as a renter, go to martinezlawcenter.com.
Yes, we can definitely help you with that.
All right. Well, liquidated damages, fascinating topic, but hopefully this helps clarify a few things.
Yes.
And we'll see you guys next time on The Deep Dive.
See you next time.
Call now 714-442-9741. Thank you.